Rising Court of Appeals Division 1 is now in session.
Good morning. You may be seated. We are here this morning on our case number 1CA-CV140410, Erdman versus Lechner and Burton. Each side's allotted 20 minutes for your argument. The appellant may choose to reserve any amount of time you'd like. If you do reserve time, you're in charge of keeping track of your own time. The clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record the proceedings, so when you approach the podium, and for the appellant both times, please recite both your name and the name of your client, so we'll be able to keep the party straight when we go back and watch or listen. We have read the briefs. We've discussed the case in our conference, and we have reviewed the record to the extent it's been necessary to do so. So with that, you may proceed.
Good morning, Your Honors. May it please the Court, Seth Kretzer. I will reserve 5 minutes for rebuttal, and I've advised counsel of the same, and I will certainly watch my time. Our first argument, Your Honors, I neglected to say I represent the Burton entities, both individually as the community, husband and wife, as well as the two corporate entities, all of the defendants' appellants. I apologize for not stating that at the beginning. Our first argument, Your Honors, really trains on the settlement agreement. This is the third tab in our record excerpts. And I think our argument here, Judge Johnson, is really has both a normative and a positive legal dimension to it. The positive is that there is very specific language in this paragraph 6 that regarding release. It has phrases like any fact, without limitation. There's no doubt that the opposing counsel has cited numerous cases where other sort of incorporation agreements maybe do not bar any future suit whatsoever, but none of those have language anywhere near this specific. That's our positive argument. As a normative argument, Judge, in our society, sophisticated business partners, business people, certainly Mr. Erdman and Mr. Lechner and Mr. Burton all were, to various different degrees. They were all small businessmen of a kind. They entered into dickered, arm's-length transactions. And specifically with Mr. Erdman, this agreement with its paragraph 6, not only did he sign, his lawyer drafted it. And generally, I believe any ambiguities in a document are construed against the party drafting it. We certainly see this in the criminal context, Judge. Criminal defendants stand up and waive rights to future appeals for sentences. They don't even know what it will be. They waive the right to waive future ineffective assistance contentions and habeas when they have no idea how their lawyer will have even performed at the sentencing. And so we really do think that the settlement agreement in this case did
Don't they have a right to withdraw from the plea in the criminal context if there's been some sort of inaccuracy or some sort of misrepresentation? There is a remedy in that setting.
Criminal defendants, Judge Catani, it's a very hard remedy to get. They are allowed to file a motion with the judge to withdraw the plea, but unless there was a reason to believe that the individual criminal defendant was mentally impaired or some severe situation like that, and that's why the plea colloquy, the things that you're asked, are you of sound mind today, any drugs, alcohol, so forth, are designed to keep that from happening. It's very rare to get a plea withdrawn.
But let me ask you, just in the civil context, the argument makes complete sense when we're talking about just information that the parties don't know, and we're just saying we're not going to do any more due diligence. We just agree this is it. But isn't that different than a claim of fraudulent inducement, that one of the parties is deliberately defrauding the other one to get them to enter into the agreement?
I don't think so, Judge Catani. Certainly not under the facts of this case. Again, the chronology here is very important. There was the original note to finance half of the sale of the agreement. Almost immediately, it became clear to Mr. Erdman that he had to continue to help out with the trade accounts, to extend credit, with the Johnson Plastics, with the Wells Fargo loan, and he chose to do those things, such that by the point in time that this $40,000, $37,000, really $40,000 bill had been rung up, he thought it was to his advantage to go ahead and have a settlement. In other words, he could have either chosen to go ahead and tried to collect on the 40, or alternatively, what he chose to do by drawing up this agreement, that is his lawyer's request that he signed, was to go ahead and try to settle for the 20. In bankruptcy court, Judge Catania, as you know, assets oftentimes, debt obligations, sell for 5-10 cents on the dollar. Mr. Erdman chose to go forward with this agreement, and he wanted to incorporate any outside condition whatsoever. So we would say, Judge Catania, under the circumstances here, even a claim of fraudulent inducement, even if a claim of fraudulent inducement were to be shown, I still don't think that would come within the ambit of this waiver that Mr. Erdman had his lawyer draw up here.
What you mean is it does come within the ambit of it.
It does come within the ambit. I apologize if I misspoke.
I want to make sure I was following. But,
yes, I apologize. Yes.
It's a strong paragraph, it seems to me, but has it been waived?
Has it been waived by the fact that the trial proceeded? And there's no doubt the record here could have been better developed with regard to some of the objections that should have been made at trial.
I don't recall that it's in the pretrial statement.
Right.
I don't recall that it was asserted at trial in any fashion.
Well, that's not completely true.
I guess the agreement went to the jury as an exhibit.
Well, Judge Gamel, if I may, just to back up, well, of course, I guess my answer to your question is two-pronged. First, of course, it was raised in the motion for new trial, so we would argue that the issue was preserved for appeal. But even when the cross-examination of Mr. Erdman is very important because he was specifically asked, and this is in our reply brief, that's, of course, Mr. Burton's reply brief, the section where he was asked, look at this language, doesn't that bar future suit on it? And he agreed that that language, as you yourself said, is strong language, would or could be read to reads that way. So not only did, of course, this contract go to the jury, not only was there the motion for new trial, we would argue that it was sufficient evidence that was adduced in the cross-examination of Mr. Erdman so as to preserve the issue for you today.
I've read that portion of the transcript in your brief and perhaps elsewhere, and I don't have it in front of me just yet here, but my recollection is that the cross-examination focused on, wouldn't you have given up this or given up that, but it didn't ever get around to rescission, as I recall.
Judge, since I do have some time for rebuttal, I will find the exact portion of my reply brief that I'm thinking of, and I will have that ready for you, so I don't take that time but
It
I will
seems to
find
me
it.
A related question is whether your client waived, your client acceded to having the jury decide the issue of whether the contract barred a fraud claim.
Well, Judge Johnson, I don't know that we could say he acceded to having the jury decide the issue. I mean, he was brought into a lawsuit. There were pretrial.
Well, sure. Then put differently, where did your client argue that the jury shouldn't resolve this issue, that it was wrong to have the jury resolve the issue? Sure.
I do believe there was a pretrial motion to dismiss. I know there was, in some portions, problems with the fact that although my clients certainly could represent themselves pro se in the individual capacity, that, of course, is not true of their corporate capacity. I'll go back and look at the pleading specifically. I do believe there was a motion to dismiss that would be broad enough written, even if inartfully, to make the argument that the entire the settlement agreement did bar the future recovery.
You suggested that it could be read to preclude any claims for fraudulent misrepresentation, but is there, if it could also be read to not necessarily include fraudulent inducement, and then it goes to the jury without objection, and I guess that's the point Judge Johnson is making, is that a waiver?
I certainly see Judge Johnson's point. I guess the only argument I would have is that, again, Judge Catani, I don't think you can get quite that far in an agreement with words like any fact and without limitation if it didn't have those particular qualifications in there. But you have my argument on my first point of error, so I'm probably not going to get further there. Even if we were to decide that the settlement agreement were to permit the suit to go forward, as it did, you still have the reality that the Arizona Supreme Court and this court, the doctrine of this state, takes a very strong view of the economic loss rule. That, in other words, that you can either sue in tort or in contract, and the object of a contract is to protect the party's expectancy in the contract, and tort is to protect injury for people and things of the sort, and absent some sort of economic loss. And I think, as you read the briefing, there may be some quibbling back and forth as to what the Arizona Supreme Court said in Flagstaff. We, of course, rely on the Orkin case, whether or not the word wholly appeared in one opinion and not the other, and maybe that is an issue that needs needs to be straightened out with your opinion, whichever way it goes, that what those cases mean. But the reality is, when you read them, they do say that economic loss rule is strictly applied in this state, and that has been a venerable rule for a very long time. So that would be our secondary argument.
Is that a jury issue or an issue for the court?
We believe that economic loss rule is an issue for the court.
And was it raised to the trial court?
I do not believe there was an objection before the motion for new trial as to about the economic loss rule. But there's the separate disagreement between my side and theirs as to whether or not it's an affirmative defense, and we think the law is very strong that it's not an affirmative defense that needed to be pled. So that was part of the other part of their argument about the economic loss rule. But to answer your question, Judge Johnson, no, I don't think it was raised before the motion for new trial. But even if you didn't agree with us on the nature of the economic loss rule, and let me just go back to that 1 second. As I parse the appellee's cases here, they want this court to atomize this down into an almost idiosyncratic context by context, in the insect removal context this and the mortgage context that. And the law cannot work in such, it has to have broad rules so that everyone can know what is prescribed and proscribed. I think the opinion, however you come down ultimately with the conclusion, has to reject this idea that this should be some sort of floating context, anchorless legal concept that should be just kind of made up on an ad hoc basis. Our first two arguments, Judge Johnson, even if we were not to prevail under the merits of those arguments in and of themselves, I do think logically lend themselves as a correlate to the third argument, which is the election of remedies. In other words, that the facts here, as Mr. Erdman pled them, did require him to either elect to rescind the contract, the settlement agreement, of course, the settlement agreement contract, to rescind the contract and sue for the $37,000 roughly dollars, or to affirm the contract and go forward with the other part of his suit, which was for the 20, which is what he thought would satisfy the economic situation he had gotten himself in. Because there was not this election of remedies, you see the confusion both in the jury's questions after they were charged and during deliberations, and then also the confusion which we think is shown on the way they answered the verdict form. And that, did you have a question, Judge?
No.
Oh, I thought you were about to ask me a question. I apologize. We argued there had to be an election of remedies here, that the facts as pled in this case do not granulate such that these were different remedies that were going to arise out of different sets of facts. There was
Did they end up getting remedies under either alternative or all the?
Inconsistent?
Yes, the particular, and this comes, try to lay this out best, Judge, at page 15 and 16 of our opening brief, and there's no doubt that under the rubric, to the extent Mr. Erdman wanted rescission, that's where his fraudulent misrepresentation claim came in. That's also where, very importantly, his conversion claim came in, which of course becomes relevant to our punitive damages claim, our fifth point of error, where in their response they start talking about felonies. But alternatively, Judge Catani, under the alternative of requested enforcement, had he affirmed this agreement and then gone forward, that's where his suit came in against Mr. Lechner and the arguments about Mr. Lechner and the sale of the housing magazine. So there's no doubt, Judge, and we would argue that is why you see the jury came back with those identical $37,000 amounts on both the first and second question. I understand that the trial judge, consolidated that, and we're obviously happy that that he did that. But I think that shows the problem here with the failure to elect remedies as the plaintiff situated like Mr. Erdman would have been required to do.
An obligation on your client to make that point to the court ahead of time?
The judge, I don't know. If it's a matter of if a plaintiff does not elect remedies when he must elect a remedy, we would argue at that point it becomes a matter of law and the court should elect a remedy. There had to be election of remedies made by some parties somewhere along the way, and if there was not, then it doesn't default. It's not like an affirmative defense that a defendant has to plead that decision should have been made for him. I've never seen that. Usually it seems to go without saying that a plaintiff elects remedies because they know they have to proceed under one theory or another, so they don't get double recoveries of this type. I think, Judge Catani, even if we were wrong on that, it is important to remember how differently the trial evidence, the paradigm in which this was presented, would have been had there been an election of remedies. In other words, if Mr. Erdman had decided he wanted to go forward with his specific enforcement, which is probably made more sense considering that's the deal he struck originally. He thought it was better to try to get the 20 than to, 20 in the hand versus 40 in the bush, to borrow from an old metaphor. Then all this evidence would not have come in about conversion. And that, of course, if you look at the lion's share, and I'm conscious I'm down to my last 90 seconds, but if you look at the lion's share of the damages that were awarded in this case, of course, that comes down to the punitives that were awarded under both classes. Now, with Mr. Lechner, of course, he didn't even plead punitive damages. I believe you have to do, and he still got punitives. But then the $93,000 and some odd that Mr. Erdman got, this enormous amount, which relative to these 4 disputed checks, I think come to a total of about $2,000. I understand we have 2 competing views of the trial evidence. Mr. Burton testified he thought it was a mistake. It was a trial they adduced to his conversion. The light most favorable to their theory. It's conversion. Fine. We're still talking here about multiples that we think violate the Arizona Supreme Court cases that we cite in our brief and every other case on punitives. And had there been this election of remedies made, then the paradigm, the evidence adduced to the trial would have been qualitatively different. I can't tell you how that necessarily would have made a difference with regard to the liability findings or the way the jury ultimately resolved that, but I don't think there's any doubt it would have made a huge difference with the amount of damages that were awarded, and especially this crushing liability.
In your view, what were the punitive damages tied to?
I think the punitive damages were tied to the conversion of these 4 checks. That was really where they were able to, and certainly in their appellee's reply brief, they say, if anything, we got a break. That admittedly this was orders of multitude. I can't even do the difference, 50-something, I guess, about in my head, a 50-fold multiple. They start comparing it to had Mr. Burton been getting a felony conviction for conversion, had he been charged with conversion of that type. And
Not
that
the
should be
interference with contract, maybe?
I'm sorry, what?
Not the tort of interference with contract?
I think the lion's share, certainly taking out the portion that was specific to Lechner, I still think the lion's share of those punitives were driven by the evidence that was adduced about the conversion of the check. And then we would attack, even separately from that, Judge Johnson, just the general, under all the factors for punitives, the amount that was given, so especially that evil mind. It's kind of funny, they criticize my brief, the appellees do, for using that evil mind. They say it's an outmoded concept, and they cite cases using that evil mind. We just don't think that's legally sufficient to substantiate the punitives that were given in this case. And I'm down to 4 minutes and 15 seconds. I will reserve the balance of my time.
Thank you.
And while you're, before we start the clock running against anybody, I have your reply here, and I believe the part that we're talking about from the transcript starts on the bottom of page 1, goes over to page 2, top of page 2. If there's anything else that you want to tell me about in the, when you come back, let me know.
Excuse me.
May it please the Court, Judge Johnson, Judge Katani, Judge Gamel. I'm Joel Sanderson, law firm Udall Shumway, here representing Kevin Erdman, the plaintiff and appellee in this matter. Mr. Erdman's here in the court with us. I wanted to introduce him. The first thing I want to say is the easy button from our perspective is on the material breach issue. If there was a material breach of contract, we established there was a material breach of contract, Burton immediately instructed Lechner not to make payments on the transferred note that was consideration for the settlement agreement. If there's a material breach of contract, the settlement agreement can be rescinded, and we definitely have the compensatory damages entitlement, the $39,000 in damages that the jury awarded.
Was the jury instructed on material breach?
It was, yes, Your Honor.
As entitling a plaintiff to rescind?
Yes, yes. I don't want to say it was entitling the plaintiff to rescind, but the jury was instructed on material breach and making a finding on material breach.
Decisions for the court.
Right,
anyways, yeah.
right. And so if there was evidence to support material breach, I'm trying to get off the tort claims first. The way the case would be resolved, assuming worst case scenario for my client is that he cannot proceed on the fraudulent inducement tort claim, he still has the material breach claim, which rescinds the settlement agreement, puts us back into the position of the extension agreement, and also having the conversion is still as a independent tort. So we have that conversion as an independent tort to justify both the punitive damages claim and just the compensatory damages claim. We don't have to deal with fraudulent inducement. If we start with the easy button, the settlement agreement was rescinded because of material breach. Then the only thing we'd have to overcome would be the election of remedies issue. So if there's a material,
Where in the jury verdicts and special interrogatories is there a place for the jury to indicate whether they believed the settlement agreement should be rescinded or not?
well, they don't get to say that the settlement agreement will be rescinded. They get to say whether there was a breach of contract, and the jury did find in favor of Erdman on the breach of contract claim. And
Is
the
that
breach
one
of
of the special interrogatories?
it was a do you find in favor of Kevin Erdman against Burton Partners and Burton's on the breach of contract claim?
Is that a breach of the original contract or the settlement agreement?
Breach of the settlement agreement. Breach of the settlement agreement. Material breach of the settlement agreement justifies rescission of the settlement agreement without having to worry about economic loss rule issues or having to worry about Section 6 of the settlement agreement. Section 6 of the settlement agreement doesn't say you waive your right to rescission, period. Section 6 of the settlement agreement, best case scenario for appellants, is that it is a waiver of rescission based on fraud. And we cite the restatement of contract section 281 that says if there is a material breach of a settlement agreement, very specific in the restatement, material breach of a settlement agreement, the plaintiff has two remedies. Number one is to enforce the settlement agreement and sue for damages, or rescind the settlement agreement and proceed on the conditions that existed before the settlement agreement.
Are you claiming, though, that this paragraph 6 argument is waived?
Well, I'm claiming that also. I mean, when I explain this case, I explain it as a decision tree. There are multiple branches off of the decision tree. If we get back to the tort claim, which is the fraudulent inducement claim, if we return to that claim, then the decision tree comes back to the question of whether or not Section 6 applies to the tort claim. Off that decision tree, we have the cases we cite from Arizona that say that a party cannot use a contract to excuse a party's fraud. That's solid Arizona law. Even if that is not the law, then we argue that that argument was waived because it wasn't raised before the jury. Judge Gamel, you pointed to page 6 of the reply brief. In page 6 of the reply brief, there's a question asking whether or not Mr. Erdman, whether the settlement agreement waived all claims, and Mr. Erdman's was, yes, up to that date. Is what he said. But that was never argued to the jury. There was never any summary judgment motion that the settlement agreement must be enforced according to its terms. So without doing that, either they waived it or they presented it to a jury and they didn't get the verdict they wanted.
I have yes up to that point, yes.
Yes, up to that point, yes, right.
Yeah, okay.
And of course, the cases that we cited say that the way these exculpatory clauses are interpreted in settlement agreements, it's interpreted to say that the fraud is a pre-settlement fraud. So if there's a pre-settlement fraud that induced a party to enter into a settlement agreement with such exculpatory language, that pre-settlement fraud invalidates the agreement. It's not just settlement agreements, contracts in general. That's the rule.
Prior to that point.
I think that's a temporal issue. I think it's at the point that you enter into the contract, then you're waiving any claims for fraud. But you can't you can't be defrauded, have a basis for rescinding the contract under promissory fraud theory, and then have a valid contract. So if there was a fraud that created that exculpatory clause, created the language,
Created the whole contract,
yes,
which includes that language.
yes, then the whole contract comes down, including that language, and that's the case law that we cite.
But if there may be information out there, there's just a lack of disclosure, but it's not necessarily clear how relevant the disclosure might be. Isn't that kind of the point of having that language? I'm not deliberately withholding something. There may be something out there. We're going to revisit that. Are you saying this is different if it's simply intentional fraud?
Yes. The cases that we cite from Arizona deal with integration clauses, and an integration clause has said that the party seeking to party alleging fraud in the inducement can't claim there were representations made in entering into the contract that caused that party to enter into the contract. All representations have been made. You can't rely on any other representations. If there was an innocent misrepresentation, if you couldn't show intentional fraud, that type of language would be applicable. But when there's an intentional misrepresentation that induced the party to enter into the contract, our cases say that a promissory fraud claim is a basis for rescinding the contract. Now, if we have a basis for rescinding the contract, then we drop down to the Fausel versus Ted Walker case that preserves the punitive damages claim.
Well, let's go back to your easy button.
Yes.
If you proceed under the tree, the branch that says that the rescission was proper because you proved a material breach of the settlement agreement, what evidence supports the imposition of punitive damages, which is the big thing this appeal should be about?
Well, then the evidence that...
Other than the conversion.
Your Honor, on this decision tree, I will be candid, as I should be, on this decision tree, if the material breach invalidates the settlement agreement, puts us back into the position before the settlement agreement, the only basis for punitive damages would be the conversion claim.
Not interference with contract?
We didn't argue that.
Not the telling, not the alleged telling of Mr.
Well, that is,
you don't have to pay?
well, yes, that is what leads, I guess that is also, that dovetails with the material breach argument, because that intentional interference with contract was also the thing that created the material breach. Erdman had a third-party beneficiary contract from Burton to receive payments on the Lechner note. Burton stepped in immediately after that and interfered with that contract by telling Lechner, number one, you don't need to pay, but number two, most egregiously, I will take the entire business back and start selling it again. So he invalidated Mr. Erdman's rights to receive benefits under the settlement agreement, which is both a material breach and an intentional interference with Mr. Erdman's contractual rights with Mr. Lechner under the house hunter's note.
But if you didn't argue that as a basis for punitive damages, then is it?
We did argue that as a basis for punitive damages at trial.
The intentional interference with contract?
Yes. At trial, we did argue there were three torts: conversion, intentional interference with contract, and the fraudulent inducement.
But if the conversion was the only tort that supported punitive damages, that's what, $3,700 worth or something like that?
It was $4,000, yes.
That probably wouldn't support a $93,000 award.
Well, the two problems with that is that's not the appellant's argument. They argued there should be no punitive damages because there was no tort plus. That's the best phraseology I can come up with for punitive damages. You have to have the existence of the tort plus something.
Tort plus is a pretty accurate description of what we require, isn't it?
It is an accurate. Tort plus is an accurate description of what's necessary for punitive damages, but that's a distinct issue from the amount of punitive damages.
Yes.
And the appellants did not argue in their opening brief that the amount of punitive damages wasn't justified. The appellants only argued that the award of punitive damages did not have a legal basis. So I wasn't prepared to address the amount issue. We do address it. I guess we do address it in that footnote where we point out that this would be a felony that would justify 2.5 years in prison. And so if we were going to have a debate about whether the amount is justified, I think that's a completely different opening brief on appeal, completely different response brief. The law on that is detailed, and we'd have to have more argument on it. I don't think the appellants fairly raised that in their opening brief. I do want to have be fair to my counsel on this side of the room and end my time unless you have any other questions, so Mr. Ricker can speak. Thank you all very much.
Okay.
May it please the court, Keith Ricker for cross-plaintiff appellee Carrie Lechner. I'd like to talk about the waiver arguments first and then go to the substantive side second. On the Lechner side, everything other than the argument that they made in the opening brief and abandoned in the reply that the compensatory damages exceeded what we asked for and the amount of punitive damages has been waived. Very clearly.
Remind me, please, which part has been abandoned in your view?
The claim that the jury awarded compensatory damages in excess of what we requested. Yeah. Clearly we asked for lost profits very clearly in that.
Is the month versus 6 months or whatever it was?
Sure, yeah.
Okay.
So that one's been abandoned, and the only other one that's that isn't a waiver argument on our side is the issue of the amount of punitive damages. But turning back to the waiver argument, on the economic loss rule, I mean, it is beyond waived. They had every opportunity to raise it below, and the effect of that is it completely colors how what the judge was able to do, what the jury was able to do, and the way that we argued the case. The overall award is incredibly fair. This guy gave misrepresented financial statements, did everything bad you could possibly do in connection with a small business transaction, and those damages could have been awarded a lot of different ways. Maybe the jury would have awarded additional compensatory damages if they didn't award the punitives. Maybe they would have done different things. But the reason why we have these waiver arguments is so you don't get sandbagged after the fact, and that's exactly what would happen here if we had to go back and retry this thing.
But it is, the economic loss doctrine is primarily, at least under circumstances like this, it's kind of a matter of law. It isn't a factual matter that the jury had to sort out anything about.
But the judge did, and if the judge...
Why can't we just apply it now?
Because we would have argued it completely differently, and the jury may have reached a different damages allocation had we had the opportunity to do that. You know, beyond a passive waiver, they actually made tort arguments themselves. How do you make your own tort arguments and then come back after the case is over, tried, jury verdict reached, and argue economic loss rule? That's just ridiculous. The waiver on the punitive damages issue, again, you know, they want to make an argument that it wasn't pled. It was raised many, many times, both before and during trial, never objected to, and that amounts to that becomes part of the pleadings according to the Arizona Rules of Civil Procedure 15B. So, turning to the substantive arguments on the economic loss rule, I don't think that parsing it on an insect case basis versus this case basis is at all what we're asking to do. The big distinction in the cases, as I see them, is where there's some expectation that the parties are going to continue to have a relationship, and then the disappointed party says, hey, you didn't perform, and maybe they make some argument that, hey, there was a pre-contract promise that you didn't live up to, and that's fraud. That is completely different from saying, you told us something about the past that we relied on in entering into this contract. Specifically, you told us that these P&Ls were accurate when, in fact, at trial you admitted that they were not. You told us that these revenues were accurate when at trial you admitted they were not. And we relied on that information to reach a purchase price and enter into a contract and go forward. It's not, you told us that you were going to help us out and give us, you know, do paper route deliveries for 2 months after the fact, and you know, only did half your paper route.
So the argument is, if the notion is that there are situations in which parties have arm's length negotiated contracts and they have the chance to set their own expectations and remedies, the economic loss rule is not going to allow one of those parties to seek a remedy or to pursue a claim that's not fairly within that contract. But your argument is when the tort, the fraud, undermines the entire contract, then the economic loss rule cannot apply in that situation.
Exactly. I mean, so going to the insect case, what the argument there is that Orkin supposedly told them, we are going to get rid of your termites, and then they supposedly didn't get rid of the termites. That's a breach of contract, whether you want to call that fraud or not. They didn't do what they said they were going to do. The same thing with the case from Gilbert.
I need a little more help because it was a pre-contract promise or assertion. Are you arguing that only some assertions are actionable as fraud in the inducement?
I'm arguing that there's a very big difference between a promise about what I'm going to do in the future versus what I did in the past. And this is an argument I have with my kids all the time. If I tell you, hey, I'm going to, take you out for ice cream later if you do well at school today, and then all of a sudden things come up and that doesn't happen. That's different from me saying, here's what I did before, and I want you to rely on that to make some decisions. Those two things are very, very different. And the same thing comes up in that Gilbert case too with the IT. Sorry, go ahead.
It's a little bit like expressing an opinion as opposed to stating a past fact.
I mean, those kind of cases always veer within the puffery. Is it really just, hey, I'm going to do this, or is it a statement of fact that somebody can rely on and that could be fraud at all? So I think a lot of the times that's what those cases actually end up boiling down to.
And so you would say that either the Court of Appeals in the Cook v. Orkin case didn't truly address fraud in the inducement, or if it did, it was mistaken.
Well, and I mean, in the Gilbert case that they cited, it clearly allows for some fraudulent inducement claims to avoid the economic loss rule. It says, no, sorry, that's the Johnson Valley Partners case. The economic loss rule will not always bar a claim for fraud in the inducement. It goes on to say, however, it may in some cases, but it says that it doesn't. Now, that case I don't think should have been cited, but I've made that mistake myself, so I'm not going to throw any stones about that.
We weren't on that panel, so. We weren't on that panel.
Yeah.
Nor am I suggesting any criticism by that.
Yeah, no. On the on the punitive damages side of the aisle, I mean, the facts on this thing are really bad. I mean, they just are. There's two separate transactions where there's intentional torts alleged that were tried to the jury. I mean, this guy made specific misrepresentations about P&Ls that took it from a $28,000 business to a $98,000 business in 1 year, where the business was actually worse than when he got it. This is something, evidence was put before the jury that this is something that is that's the defendant's business. So he has the opportunity to do it again in the future.
What tort or torts support the punitive damages that your client was awarded?
Fraud and fraudulent inducement. I think it's a little bit of a cleaner.
Or separate, fraud and fraudulent inducement?
There were two separate claims made.
What's the second fraud that's different than fraud and the inducement?
I think they're the same. So
it's the same misstatements.
Same misstatements, whether they amount to two separate claims or not, I don't think matters for these purposes. The remedies are different, but punitive damages would be supported by either of those claims, I believe. There's really the second case that they cited about the car odometer being turned back. It's not even a punitive damages case. It's a discovery sanctions case, and it just offhand mentions that that they didn't award punitive damages. I don't know why that was cited. I think the evidence is clear. My time's up, so unless there's any questions, thank you very much.
Thank you.
The first point I'd like to make in rebuttal, Mr. Erdman's lawyer, I think, and mostly Judge Gamel, were talking about the temporal aspect. He specifically used the word temporal, talking about any misstatements made up and to the point the settlement agreement was reached, but anything that happened after that would have been, fair grist for the mill. The problem, though, is that the last sentence of paragraph 6 reads, quote, "This agreement is intended to be and is final and binding upon the parties." There's other language in there about the entire understanding. We would argue that to the extent an agreement would have this temporal aspect, and I can certainly understand that legal concept, that condition, or a condition of the road, is also foreclosed by the exact language of an agreement that Mr. Erdman's lawyer drafted and he signed. So that would be our response, getting back to our broadest argument. On the economic loss rule, I think...
Before you leave that, what's your response to the breach of the settlement agreement as a basis for rescission? Directing Mr. Lechner not to pay, wasn't that a breach?
Well, Judge, I don't know. The testimony on that point was a little bit more unclear, but as to when he had been instructed not to pay versus Mr. Lechner's own problems with the situation and the business and house hunters. But even then, I still don't think that would rise to the level of a fraudulent inducement. And even then.
Here we're just talking about whether you can rescind the settlement.
Sure, even on, maybe I'm not being as articulate as I should, but even on the subject of rescission, one of the risks that Mr. Erdman bargained for in taking the settlement agreement was a non-payment by Mr. Lechner for, I mean, he could have passed away or his business could have gone bankrupt. I mean, he had chose to buy a, supposed $20,000 payment over here because he thought that was a better credit risk than the $40,000 he had over here. Non-payment by Mr. Lechner, I think, was a risk that was within the conception of the settlement agreement. Certainly,
But
at
he
least
didn't bargain for Mr. Burton telling Mr. Lechner, you don't need to pay, did he?
not without any other justification to do so, no. But even if he didn't bargain for that specifically, I'd argue the contract is pretty broad, you still have the problem that they, even if he has somebody who bargained for, he still disclaimed any reliance. And reliance, of course, is in the title, no reliance on a party. Reliance is a core element of fraud. So even if it wasn't a risk that was encapsulated within the agreement in and of itself, you still have this other language that waves away and says we're not going to have future lawsuits about it as our final understanding. I mean, I understand it's incredibly broadly worded language, but that's the language they chose.
So what I understood Mr. Sandus to be arguing is that there are, under the restatement, there are at least two grounds for arguing that a contract should be rescinded. One is fraud in the inducement, and the other is a material breach. And what I understood you to be saying is that, well, the fraud in the inducement claim is barred by the contract, the language of the contract. I'm not sure I read that provision in the contract to waive any claim relating to a future material breach.
Well, Judge Jensen, and I don't mean to belabor the point, but I would just again recur to the very last sentence of paragraph 6, which says this is intended to be final. So no matter what else happens after this point, as per this agreement, this was meant to be final, which certainly makes sense under the situation as it was. These two both wanted to move on. Mr. Erdman wanted to consummate finish what he thought was a consummated sale of his business. Mr. Burton wanted to get in the business of running the business, not to be redundant. It certainly makes sense that they intended this settlement agreement to be final. Let's all go resolve what we have to resolve together and go our separate ways and not deal with each other again.
So what's the remedy when the payments don't come in? That's only a remedy now. It's not a remedy against Mr. Burton at that point.
To the extent there would be a remedy, Judge, it would not be one that would arise out of suit, a breach of contract. He still could have sued in a tort if he had wanted to, even if you didn't buy our economic loss rule argument. But we would agree, yes, that even in that situation, any other future misconduct, even if it were to rise to that level, would nevertheless be barred under the language of this contract as it's written. I see I'm out of time, but if I could just have 20 seconds to make one last point. And that's that as through the course of the argument, the police I hear their argument change, I think, from what they wrote in their briefs about the economic loss rule. I think Judge Gamel had it correct where he said this is not an affirmative defense. Everyone agrees with that. This is a category of damages the law either permits or does not permit. To my mind, that's not unlike a court that discovers it was without jurisdiction. One does not need to object in a trial court to preserve an objection as to jurisdiction. The lawyer at the far right said it would be ridiculous to, allow us to be sandbagged and make us go retry the whole thing and so forth. Unfortunately, that's how certain arguments, certain legal principles work. We would argue that category of damages is barred vel non. Thank you for the extra time.
Thank you. Thanks to all of the lawyers for your arguments and your briefs. We'll take the matter under advisement and we'll issue a decision in due course. In the meantime, we'll stand in recess to allow the court to be reset up for the next case.